Okay. We have one case left on the docket. When you're ever ready to proceed, we'll go forward. If you want to let me know how much time you want for rebuttal, I'll set the clock so that the light turns yellow when you're into your rebuttal time.
20 minutes total?
Correct.
And so if I use 15, I can use 5 for rebuttal?
Correct. And so I'll set it so the light will turn yellow when you hit the 15-minute mark and have 5 left.
And your justices, right?
Judges.
Justices.
If you want justice, you have to go to Tallahassee. You only get judgments.
Well, I didn't want to offend anybody. Justices, my name is Thomas SHAFOVALOFF, and I am the appellant and the plaintiff in the underlying action here. It's a case, a claim, tried in Orange County at the beginning of June in 2010. The result of the trial was a 0 verdict. There was an interrogatory verdict. There was the typical questions about permanency, future pain and suffering, medicals, past. That was all on the verdict form. Very typical, but it was a 0 verdict. The appeal addresses about 4 separate issues, probably 3 major ones, but they're interconnected. And I'll start with the first one. During this litigation, my first counsel wasn't terribly interested in proceeding until I had an operation. Evidently, the cases are easy to settle once you have an operation, for instance, on my neck, which my orthopedic surgeon has recommended, and my back.
Okay, well, I'm going to have to ask you to stay only on matters that are in the record.
All right. In any case, the case was tried with 0 verdict. I hired a lawyer in Tampa about 3 months before the trial was set. And about 7 days before the trial was to begin, he filed a motion to withdraw.
Now, prior to you hiring an attorney, you were representing yourself?
Yes, sir. Yes, Your Honor. Yes, Justice. But I had a prior lawyer.
At the time you filed the notice that you were ready for trial, you were representing yourself, correct?
Yes, I did.
Okay.
But I changed my mind. And I hired the lawyer in Tampa, whose name is in the record. And about 7 days before trial, he filed a motion to withdraw. And it's not in the record, but he was unprepared. And I didn't get the notice immediately. I got the notice by facsimile. And the situation was the case had been continued so that I could hire a lawyer initially.
You said your lawyer withdrew. As I read the record, and we're talking about issue 2, but as I read the record, it looked like you discharged your lawyer, and the trial court made it very clear on the record that he would not have allowed the lawyer out if the lawyer simply sought to withdraw.
He filed the motion to withdraw. I found that he had been unprepared. And so I went to Tampa to collect the file, and to collect the file, I discharged him. I was in a situation, extremist situation. I had to do something. If he was unprepared and the case was going to have to go to the trial, it was going to be a disaster. And so what kind of disaster was I going to have? A disaster with somebody who had no significant experience trying a personal injury case, or a disaster with myself, all right, where the court was going to mandate, I anticipated, considering the demeanor of the court, that I try the case. And the court, if you take a look at the record, says that I remained counsel of record in the file when I first took it over. And When you take over, people don't like trying these cases. They don't like working them up. So what I decided to do was work up the case so I wouldn't have an argument from somebody who was lazy for their 40% on the case.
Let me tell you my concern.
I'm off the record, I know.
No, my concern on this issue is, of course, it's an abuse of discretion standard, a very high standard. But the fact that when you were representing yourself, you filed a notice for trial, that was in essence a representation to the judge that I, the attorney, and my client, in this case we wanted the same, are ready for trial. Please go ahead and schedule the trial.
I think it's significant that I did hire a lawyer at that point. That I hired a lawyer because I knew I couldn't try the case, particularly on my medication, by myself. I might be able to assist somebody who had experience.
But do you understand that the,
yes, Your Honor, I do.
The essence of a notice for trial is you're represented, you're prepared to go to trial.
Yes, I do. And
so why shouldn't the trial judge have accepted that view that you were ready to try your own case?
Because I hired a lawyer. And I was taken out of the process when he took over. Now, the court says I remained in, but if you take a look at the record, the notices only went to the lawyer I hired. It was made very clear that I was not to participate in any judicial proceeding by filing any motions whatsoever after the lawyer in Tampa was hired. So I wasn't to get involved at all right? It was made clear to me at the hearing. Mr. SHAFOVALOFF was not to contact the defense counsel, all right? And now I'm off track, but that's what took place. If I'm not, how can I be ready if I hired somebody to get ready for trial and I'm not supposed to participate any longer? And as a matter of fact, Mr. Berman, that is the lawyer in Tampa, he asked me to file a notice of a limited appearance for a hearing because he was unfamiliar with a pretrial matter. And that was just before he withdrew. All right? And I did what he asked me to do. But it was for the limited purpose of pretrial matters, not to participate as the trial counsel. So I respect the order with which this is approached, the notice for trial, but I did hire a trial lawyer to represent me. And, of course, I am aware of the significance of the discharge, but at the time, my choices were very limited. And after I discharged them, I tried to find another lawyer. That's not in the record. But I was told I had to get a continuance before they would be interested. It's not as if I didn't take any steps to find another lawyer after I had the lawyer file the motion to withdraw. This was not a month ahead of time. This was 7 days before a case that had been continued before so that I could find a lawyer, or because I did find a lawyer who withdrew immediately before a specially set setting. So I don't know if I've mixed up the order, but I think that's the order in which things took place. And there's only so much I can do. This morning I'm not on medication. The fact that I'm on medication is part of the record. I've only taken my blood pressure medications this morning, none of the narcotics that I'm on typically.
Let me ask you a question about the zero verdict and the damages in this case.
Yes, Justice.
There were certain damages that would not go into the verdict, is that right? If they were PIP damages or whatever? I mean, there were certain things the jurors could deduct or get rid of before they awarded you damages,
yes,
right?
Judge.
Is there a view of the evidence which would indicate that the jury could have found that although there were damages, all of them were covered by things that were excluded, that would be properly excluded from the verdict?
My recollection is that there is no evidence contrary to the cost of surgery and that would be necessary.
You're talking about future medical?
Future medical, yes.
But
And past medical.
But didn't the jury find no permanent injury?
They did, yes,
Okay, so
Judge. There was a no on the rest of the verdict form.
Right.
Negative responses.
And there was certainly, I mean, we have a very limited record, which is one of the problems that we have in trying to address any issue related to the sufficiency of the evidence. But from the deposition testimony of a witness that testified for the defense, there was evidence that the jury could have believed that there was no injury from this particular accident, correct?
That's a possibility.
Okay.
But that's also it's unlikely. And there's an IMA report from the USAA Dr. D.C. that is terrible for USAA. It parrots all of my doctor's findings very closely, and that particular—
That was Dr. Thornton?
Dr. Thornton, who was approached by the defense.
That was not placed in evidence, correct?
Yes, it was. Yes, that is part of this record.
It's part of the record, but it wasn't part of the evidence.
The judge would not permit it, and I was put in a situation where the defendants, who didn't want to continue the trial, I learned that they had talked to Dr. Thornton, and that he was going to change his opinion about one aspect of that.
Again, you need to limit yourself. We're going to decide this based on the record on appeal, and we're not going to consider matters outside of the record. So, I was given the opportunity to put Dr. Thornton on the stand without the opportunity to depose him because of the court's interest in moving the case along. let me ask you about the first issue. I'm having a hard time seeing how that issue is preserved with respect to an inadequate verdict. The motion for new trial didn't raise that as a ground for a new trial. So,
Your Honor, the record reflects the court ruled on the paper motion before the 10 days had run for the 10 paper motions, and it does not say directly that the zero verdict, but what it does say is that something happened, and there was the introduction and argument through questioning from defense counsel that the VA was going to take care of me, and so there was some reason why we had a zero verdict, and that's the closest argument that I can provide to the court that something had to be done. My lawyers had evaporated. They were not there for the whole trial to begin with. And I was surprised that anybody showed up. I had not invited Ms. Cheatwood to show up. She just walked in and sat down. And at trial, I was put in a situation where if I sent somebody totally experienced away, there would be the argument that I abandoned the opportunity to have representation when I could have had representation. And this is not, Ms. Cheatwood was not invited. And so I had to make the decision on whether to keep Ms. Cheatwood there, who, and I can assure you, totally inexperienced in these things. And at the second day, all right, and I can't, if I say it again, that's the only way I can stress the lack of preparation and experience of the lawyer in these matters. She may know some criminal work, but not this personal injury. And I was the only lawyer there, and there were two lawyers on the defense side. So without my opportunity to participate with Ms. Cheatwood there,
I mean, as a general rule, a trial judge, I think, has a duty to give a party adequate time to prepare for trial, but the trial judge can't make an attorney prepare for trial. And I'm wondering why it would be an abuse of discretion to refuse a continuance for a party that had time to prepare for trial if they hadn't done so.
Well, I hadn't prepared for trial.
Right.
I mean, I hired a lawyer because I knew I couldn't prepare for trial. I couldn't do the trial myself. How can I prepare for trial? You know,
Okay.
I'm only here today because I take my medication most of the time. And I'm only here before you because I didn't take some medication that I probably shouldn't take before I even go to a hearing. The court was on notice that I was on tramadol and hydrocodone. It doesn't take a genius to realize that that lawyer should not be trying their case by themselves.
Okay, you're into your rebuttal time if you want to save the rest of the time.
Your Honor, I realize there are some issues that you would like that you address. My continuance, motion for a continuance, I had blood pressure, and this is part of the file. I was 190 plus over 125 when I went into the emergency room when my medication wasn't working. I had a judge who took the position that I was a fake admission to the emergency room. If you've done any trial work, you know that you have to have all your witnesses ready to go. And since I'm a sole petitioner and I'm put in a position where I had hired a lawyer to prepare the case who didn't do it, and now on medication and everything else, now I'm in the emergency room, what the heck can I do before the first day the trial begins? And what fool is going to walk away from treatment when their blood pressure's over 190, over 125? It would be a fool. I'd rather be here arguing this and lose. All right? And spend 3 days in the hospital before the trial than not be here.
Thank you.
Good morning. May it please the court. Jamie Bellotti-Moses on behalf of the appellee, USAA. Here today with me is my partner, Phil King, who tried the case. We are seeking an affirmance of the final judgment in favor of USAA. The issues raised on appeal, we do have preservation issues with respect to the verdict. If it was inconsistent, it should have been raised before the jury was discharged. If it was inadequate, it should have been raised in the motion for new trial. The motion for new trial raised 2 issues. One with respect to the VA, and it says specifically in the motion, if counsel's recollection is correct, this is what was said. That wasn't what was said, and Judge O'Kane would be the one that would be best to remember if it was said or not said. The second issue was the argument regarding the continuance and whether it should have been granted or not. Judge O'Kane determined that a motion for new trial was not warranted, and she denied it. The issue with respect to a zero verdict has not been preserved, but even if it had, as Judge Palmer recognized, there was sufficient evidence that there were over $60,000 in PIP payments that covered any damage or injury that the appellant, I don't want to mispronounce his name, that the appellant offered as relating to the accident. The jury did not find a permanent injury and therefore did not award future meds or past pain and suffering, which they were instructed to do with instructions provided to them by appellant. There is nothing to suggest they didn't follow their instructions. The second issue with respect to the continuance, just to clarify the record, before or as Mr. Berman, Chris Berman was hired, and I think he'd be offended to hear that he doesn't have experience because I know him to be an experienced attorney, he requested a continuance. He came in and said, Your Honor, I've been hired, I'd like a continuance. Judge O'Kane granted the continuance. She set it for a date certain in June, and she specifically said, I will not grant another continuance. 7 days before trial, he moved to withdraw. He was discharged, and Judge O'Kane said, I wasn't going to let him out if you didn't discharge him, but you discharged him, so I let him out. We're going to trial. The next continuance after the ER visit, a document was presented. The ER doctor said, see your primary care physician the next day. Appellant testified he did not see a primary care physician. Judge O'Kane granted a second continuance and said, fine, I'll give you another day to see a doctor. Come back with a note that says you can't proceed. He didn't come back with a note, so they proceeded. I don't know how an abuse of discretion can be demonstrated on this record. Third issue with respect to Dr. Thornton, I'll just get through it briefly. Dr. Thornton was there at trial, ready to testify, and never called. I don't know how we can lose a motion in limine to have him excluded. He's allowed to testify. The judge says you can ask him all the questions you want, but I'm not letting the IME report in because it would be hearsay. This is what you need to do. He doesn't get called, and she's abused her discretion. It doesn't make sense. And then finally, the fourth issue with respect to the Rapetti lawsuit, there is an allegation or a suggestion that there's been an error in allowing us to amend our complaint. We never amended our complaint. We never sought leave to amend. Rapetti would not be a Fabre defendant. We would not try to make Rapetti a Fabre defendant. It was proper impeachment testimony regarding the prior accident and lawsuit that was not objected to, and appellant was questioned by his counsel about it on recross. So, unless the court has further questions, I will rest on my brief, and we would just ask that you affirm the final judgment in favor of USAA.
Thank you.
I suppose it's my last...
Rebuttal, yes.
There's only 3 minutes, all right? And I would not know what Judge O'Kane was or was not going to do. After the fact, it's nice to hear what she would have done. All right. But I don't know what I had no idea. I don't know what she would or would not do. And the demeanor of the court in requesting that I go there was a dispute about what the hospital records said about what I was to do. The court told the plaintiff, me, that I had a week and then to go to see a doctor. In parentheses, it said 1 day. The court, there was a dispute about how long I had to go to see a doctor. So I had to take the document to the judge and show her, see here, it says 1 day. All right. My orthopedic surgeon is not in town. The only people in town that I have to see would be the VA. And the only thing I got to see was a nurse, briefly. That's all. And it was quite clear to me that there was not going to be a continuance. That medical record from USAA is not a typical IME report. It suggests the treatment necessary. It's very detailed. It's not a typical report. I think it's a medical record. I think it's something that could be actually admissible without any further foundation, other than the fact that it's a medical record, one of my medical records, and he's listed as a treating physician on the expert on the witness list. And Rapetti, I tried to address that with the court, with Judge Morrow Smith, and her response to the motion to consolidate the Rapetti with this litigation was to set a special setting, and that was her response. And there was no indication from the defense counsel that asked me if I was hurt in the prior accident. I told him no. So there's really, other than, and I couldn't get, I didn't have the opportunity to get the prior lawyer who filed the suit in, and there's records in the file that indicate that it was filed at the statute of limitations.
Okay. Thank you very much. Court is in recess.